here, everybody. Just a little about me. I'm an elder law attorney in Lafayette Hill, just sort of general practice, estate administration, estate planning. Ended up doing a lot of guardianship because I am also regional counsel for Liberty Healthcare, which is the agency that does the under 60 adult protective services in Pennsylvania. Prior to going into private practice, I worked for an organization called CARIE. Off and on, I worked in the ombudsman program, so I really came from an approach of advocacy and trying to preserve autonomy. I've done some public policy stuff, so kind of all over the map. But anyway, I think what we're trying to do, because we only have an hour and a half, and I have to finish before the tree guys come back and start. Not good scheduling on our part, but they graciously took lunch. But just try to walk through the basics of this in an hour and a half. When to file and when alternatives are possible. If guardianship is the right choice, what are the nuts and bolts of making your case and filing and getting through a hearing, and then counseling your clients on what's gonna, the responsibilities that come with guardianship and the reporting and everything that comes after that. So I'm gonna do share screen right now. There. Can everyone see the PowerPoint? Yes, okay. All right. Okay. So I just want to start, there's this PowerPoint, and then which is part of the handout, and then the appendix to the handout, a very rigorous appendix to the handout that has the statute and samples of reporting and a full filing, which includes a citation and things like that. And if I can just start at the end for a second, the last slide of the PowerPoint segment of the handout kind of takes you to the sources. Everything you need is kind of there. The statute, the Orphans Court rules, and different websites that contain the forms that you might need to accompany a petition. So I just want to start out briefly, kind of an overview, right? So why, what's the purpose of guardianship? The statute has a purpose statement, and really it's to support and protect the interests of an incapacitated person. And if you look at that definition of an incapacitated person, an adult whose ability to receive and evaluate information and communicate decisions is so totally or partially impaired that to manage his his financial resources to meet essential requirements for physical health and safety. So it's not just simply, a person with a disability. I think that that definition puts the onus not just on what a person's physical conditions are, but what is the nexus between that impairment and their inability to make decisions, and how is that person at risk? So when I go through the elements of the case, you'll see, people will come and just say, well, I don't like the decisions, and often the client, who is the petitioner, is the child of a senior citizen, and they may believe that mom isn't or their father isn't making good decisions, or increasingly I see parents of children who are persons with disabilities, but now they're 18 or 21 and they believe or someone's told them they need guardianship, and in some cases they do. But really trying to say it's a very weighty thing. It should be a last resort, and we have to show that not just someone has some limitations, but that those limitations are putting them at risk, and that guardianship is the way to mitigate that risk, not just a magic bullet or something like that. So the jurisdiction is an orphans court in the county where the person is domiciled. It's all pretty self-explanatory. Types of guardianship. So there are plenary guardians and limited guardians of the person and the estate. Guardian of the person, their role is to make decisions about the health and safety, well-being of of that individual. And that includes things like long-term services and supports. If people are in nursing facilities or getting services at home through the waiver, supports coordination, things like that, to be almost in a way a care manager in certain situations. Guardian of the estate is what you would expect, is to oversee financial resources and make sure that those resources are used for in the best interest of the incapacitated person, and are managed properly. Emergency guardianship is really, should be limited both in scope and in time period. As you can see, that, you know, a lot of times that's, at least in Philadelphia, and I don't know, other people have had an experience, like it's a very high bar to establish that you need an emergency guardianship petition. Often it's someone, a healthcare decision or surgery or something has to be made. Hospitals are often the petitioner, that there's just nobody around to make that decision and a person's life is at stake. So as you can see, it's irreparable harm to the person or the estate of the individual. And that order only stays in effect for a limited period of time before you have to have a full guardianship hearing to show that an ongoing plenary guardianship is necessary. So when is guardianship necessary? You know, your client is usually the petitioner, a family member, concerned friend, and they're coming to you with a problem because they have, you know, someone they care about is in a bad way. They're making decisions that they think are problematic, or they can no longer make decisions. So it's important to get all the facts, and not, so what I sometimes see is people let the outcome lead them to believe guardianship is necessary. My mom is making certain decisions that are troubling to me, but that doesn't mean they're an incapacitated person. So they sort of back into guardianship. And you have to remind people that this is not simply a clinical thing, it's a legal determination, that you have to, you know, understand the elements of that, and that it's not, you know, I've had people come in and say, well, the doctor told me, or the social worker told me I needed to be the guardian, or my mom needs a guardian. But the first question is the person incapacitated, right? A couple of, you know, I've had situations where people come and they want to sort of prospective guardianship. Everything's okay now. I had a case, actually, I was the court-appointed attorney. I was on the other side for a case in Montgomery County, and the husband had power of attorney and everything was under control, but he was worried about what was going to happen in the future, which my view of that was that wasn't really the role, and I understood his concern. But, you know, it can't be driven by, this is a big deal, you're stripping someone of their rights. And so it's important, you know, that there's an issue at hand that needs to be addressed with the guardianship. I mean, one of the questions I'll always ask is, you know, okay, so say we get a guardian. How will having a guardian solve the problem that's before you? We have a client with a daughter, she's probably 21 now, she's an adult, who has some behavioral health issues. And she will, there's sort of a pattern where they try to get respite, or the daughter might go to try out a residential services provider, community residential services, rather than living at home, and kind of sabotages it, falls through. And then the mother will call and say, I need guardianship. And we have to keep explaining over and over, your daughter isn't incapacitated. She's, you know, got an issue that even if you were appointed guardian, you're not going to be able to, first of all, she's not incapacitated, but even if we could make the case somehow, or she was, and you were appointed guardian, you wouldn't be able to force your daughter to stay in the residential services program. That's not the purpose. That's not going to really, you know, there's this sort of, if your only tool is a hammer, everything looks like a nail approach to this sometimes. And you just have to kind of talk people through that and look for other alternatives. So, say you're looking at the part of this is like looking at the elements of a case if you're going forward. That it's not just focused on the limitations of the disability that the person has, but showing that those limitations are linked to circumstances that put them at risk. And then finally, even if that's the case, that what is the causal relationship between those things, and then what is the need for guardianship services? If there are less restrictive options, such as powers of attorney. Pennsylvania has, someone might have done a healthcare power of attorney, and even if they don't, in Pennsylvania, part of the Estate and Fiduciary Code, Chapter 54, creates the option for a healthcare representative for someone who isn't competent to create that writing, so that a parent or an adult sibling or somebody, there's a hierarchy of relationships where someone can step in and support that person and address any issues that might go unattended without the need for guardianship. There's a not so recent case now, 20 years, 22 years, in Repiri, that kind of, supported that, where the person met the clinical definition, they had the limitations, but what the court saw was that the alleged incapacitated person had a circle of support, and there were other mechanisms in place that without which she would have been at risk, but because they were in place, she wasn't at risk. And I think the courts are starting to look at this. I just had a recent case in Montgomery County, and I probably could have even done a better job from the beginning at looking at being creative. But the parents, their daughter was an adult; she's now in her 30s, and clearly, intellectual disability on the autism spectrum, and so we filed the petition, and in vetting that, and the court, along with the court-appointed attorney for the daughter. Well, let me back up. The parents had the presenting problem for them. They were starting to get sort of pushback from healthcare providers. They were having, other service providers saying, well, we can't talk to you because you're not guardian, or you really need to be guardian. We have to talk to your daughter. And of course, that wasn't really an option. So once the petition was filed, the court-appointed attorney, and we got some input from Disability Rights PA, and really came up with a creative solution. This is solely Montgomery County right now. I don't know if other counties are going to look at this, but the judge did issue a decree of adjudication of incapacity, so that was clear. But the mother was the rep payee for the young woman who only received SSI. So her income was taken care of, and there's a report filed for that with Social Security. The parents had created a special needs trust, so if any additional resources had come to the daughter through an inheritance or family members inadvertently making gifts, or when the parents passed away, that wasn't going to affect her SSI or eligibility for Medicaid. And because the fiduciary code says that they can be healthcare representatives, everything was kind of taken care of. They had some concerns that doctors and these other service providers were going to push back, so the judge issued a decree citing the statute, recognizing them as healthcare representatives for all those purposes, and they felt comfortable that if they had to go to the doctor and could show them something that a judge signed, that would do it. And so that obviates the need for reporting and every decision being under the court, and it was a good solution. And they've done it a number of times, and the judge said they've been doing this for several months or a year, and so far so good. No one's had to come back and say, oh, this isn't working, we need a full guardianship. So again, it's really weighing the pros and cons. The advantages, of course, of guardianship are that it's all encompassing and eliminates any, question marks or guesswork about who the decision maker is or what rights the individual has. But the disadvantages, as you can see in this slide, there's a whole reporting system, which we'll talk about later. A lot of things that should be family decisions become part of needing court approval. And then there's just the aspect of it that the autonomy of an individual, guardianships are pretty comprehensive, and you lose many, not all your rights, but many of your rights. So it's really just a matter of weighing those options. So say you run through all these alternatives and you've analyzed the problem, and really guardianship is the only route you can go. So how do you do that? Where do we file? What are the nuts and bolts of this? Jurisdictions in orphans court, in whatever county the person is domiciled. If they're in a residential services, nursing home or a group home or something, you can file in that in the county where that residence is located. And hospitals may be the petitioner in a case for emergency guardianship for a limited time period. And so anybody can file if they can show that the filing is designed to support and benefit the alleged incapacitated person. I actually have had a case, one of my first cases in private practice. It was clearly there was a dispute between a mother and a daughter-in-law, and it was clearly retaliation by the son to try to have his mother declared incapacitated. It didn't go anywhere, but those things happen. Who may be appointed? Any qualified individual. I mean, in most cases, if someone has a child, a sibling, or somebody, a family member is always best, who knows that person. But then, and I see this in my protective services cases a lot, part of the reason they're with protective services is that these are individuals that don't have a circle of support, don't have families. And so often we have to use an agency guardian, a professional guardian, could be a nonprofit. If the person can communicate to that degree, they should, the alleged incapacitated person can express their preference, and the court would take that under advisement. So you proceed by petition, and I won't obviously read through all that, but the elements, what needs to be contained in the petition is all laid out in the statute. In Orphans Court Rule 14, that should say 14.2. I'm sorry, it got cut off. The big piece of it all to establish incapacity is to get a doctor's report. There's an expert report. That form is in the appendix in the handout. I mean, that's step one. And often, I've actually seen petitions filed without the doctor's report, and they just use the language of the statute to establish incapacity, but that's not, in my view, good practice. The element, the details and the facts that the description and all that from the expert report should really shape the petition, and the part of the petition that's averring that the person has functional limitations that are putting them at risk. So the petition, the relief you're asking for in that initial petition is a citation. You're asking for jurisdiction. That's how the Orphans Court gets jurisdiction over the alleged incapacitated person, and saying, it's a rule to show cause, come to court and say why a guardian should not be appointed. Along with the petition are exhibits. Well, and the big one is, as I said, the expert report. The court will accept that in lieu of in-person testimony. I'll explain in a few minutes. There is a variation on that. But that's really the pivotal aspect of your case, and it should be, there's a description of who they'll accept that report from, but my preference is a psychologist or a psychiatrist or the treating physician who actually really knows the person, and can speak to their limitations and the whole universe of their diagnosis or whatever, or how that limitation is putting them at risk and causing them to be considered an incapacitated person. Along with that exhibit, these aren't exhibits, but you need to include, and there's a full filing in there, so you can look at that sort of front to back. The citation, which is a form, a preliminary decree, which is also a form which awards the citation, schedules the hearing, and then a proposed final decree, which, that almost, most of these things are forms, but the petition and the final decree should be individualized to the issue and should be descriptive of what you aver and what why there's a need and what findings the court is making regarding that person's incapacity. Another exhibit that must be included is a consent. There's a form, again, all forms, that the guardian consents to accept the guardianship. In Philadelphia, there's an additional guardian confirmation form that they have you submit. Everybody, not just a professional guardian, even family members, should complete a state police criminal record check. You can do that online, and it has to be dated within 6 months of the hearing. And if it is a professional, you should also include any documentation of certifications, training, things like that. You also see in the materials, at the end of it, I think there's the filing, and then I included an addendum. I'm diverting a little from what I was talking about, just to point out why that's in there. It kind of goes back to the alternatives, and I should have mentioned it earlier, but there's an addendum in there. I mean, it was actually a case I did for Christian Legal Clinic, where this woman was a caregiver for her mother. Her mother was very impaired, and we, just having problems. She wasn't being able to appeal a waiver, service denial, and things like that. And English wasn't her first language, and Spanish isn't mine. So as I was gathering information, I was gathering it as I went. I filed the petition, but then realized, as I mentioned earlier, she was the representative payee for her mother's total income, social SSI. Her mother had nothing else. And so there really was no need for a guardian of the estate. I didn't realize that till after we got, sort of into the process. But the option to be the sole healthcare representative was a little more complex because she had multiple siblings, and they weren't opposing her being the guardian, but she would run into healthcare providers who were not necessarily going to recognize her as the sole decision maker. So where we came down was just to get guardian of the person, to take out guardian of the estate, and all I had to do, the court just said, file this addendum, and when we, in a new proposed decree, and we'll take it off the table. And what that keeps her from having to do is file. And if you look at the guardianship reports, the guardian of the estate, that report is really complicated. It has to be done online. And so it was a good outcome because there was no need for it. Plus, it really saved her the trouble of having to, plow through that report every year. Once the procedure for filing is e-file in Philadelphia. Montgomery County still, as it says, Bucks, they're still doing mail, but they told me they're getting there. And once you file your petition and it's accepted, the court will issue a citation, and they'll usually reach out to you first to try to, to schedule, what dates work, and if to schedule the hearing. And one thing to keep in mind when you're scheduling or working with them on scheduling is that there's a notice requirement, as you see in the next bullet point there, that the petition, the filing, the citation notice, everything has to be served on the alleged incapacitated person and any, and you can see what the interested parties are below within 20 days of the hearing. And the service on the alleged incapacitated person has to be in person. So keep that in mind so that you're not up against that deadline, you know, knowing that you have to do that within 20 days of the hearing. And giving yourself enough time to serve the citation and the petition and everything. Prior to the hearing, once you get, you know, you have to make service. There's a couple other tasks. One is to, so the alleged incapacitated person has a right to attend the hearing. And one good thing about, let me back up, one good thing about serving the petition and citation yourself is actually, if you haven't had a chance, it gives you a chance to actually meet the alleged incapacitated person. You can ask them, you know, inform them of their rights, find out from them if they want an attorney, and it really gives you a sense of, you know, what's going on, if it's a family situation, and the appropriateness of what's happening here. But that person has, and you want to let them know they have a right to attend the hearing, urge them to attend the hearing. It's much easier now with Zoom. And the law provides that they have a right to attend that hearing. They should be present, except for the conditions that are in that bullet point, right? Unless it would be harmful in some way to them. But it's, you know, harmful to them, not inconvenient to the petitioner. That's not an okay reason for excusing somebody. And you also have to let the court know if the person requests counsel, or if it's your recommendation that counsel be appointed. Montgomery County now appoints counsel in every case. And, you know, depending on the situation, if you think it's going to be contested, if there are other family members who may oppose. My cases with protective services, I feel like I always try to get the court to appoint counsel because, you know, it's protective services, which is, I mean, we're only filing petitions to address a protective services issue. It's very, you know, it is definitely a last resort, but still, we're a subcontractor to the Department of Human Services. You know, it's the long arm of the government, and I feel like the consumers should always have more, you know, something to sort of equal that balance out and speak for them. But if you do believe that the person needs counsel or they've asked for it, and you write, when you submit that letter, I often, just as a favor to the court, I'll put in a proposed decree for counsel, you know, it's a courtesy. So the hearing itself, the burden of proof is on the petitioner to prove not only incapacity in the sense of, okay, here's this person has these functional limitations that put them at risk, but the need for guardianship, right? So you're using the expert report is going to be your evidence of incapacity, but it's usually the petitioner, or, you know, if it's a protective services case, it's an investigator, whoever's been, you know, close at hand to that situation, who can really explain why there's a need for guardianship and there's no other alternatives. One thing you want to also find out, so the expert report, more often than not, will be accepted and entered into evidence. But if the alleged incapacitated person or their counsel requests, Rule 14.3 allows them to make a demand that for in-person testimony. And if, you know, you want to find out early if they're going to be willing, if they're going to want that, because it's hard enough, and you may see, to get the doctors to complete the reports at times. That's actually often the most labor-intensive part of doing this. But then if they got to come to court, and you're going to, you know, they don't want to do that, but if you know enough ahead of time, you can give them notice and everything. But you know, that's if they feel like there's some question, or they want to cross-examine the examining physician or psychiatrist, they have that right to ask that person to come to court to do so. The rules of evidence are somewhat relaxed, you know, depending on the judge. You know, you can sort of ask a leading question every once in a while and things like that. And so the first part of it, you know, you're you're showing proof of service. You have to submit proof of service that everybody's been served in a timely manner and in the manner that's the law requires. And then often the judge will accept the expert's report and then read it into evidence. And once, then the bulk of the case is really establishing, in addition to that, the functional and the clinical issues, that there's a need for guardianship. And it's often the petitioner, if they're the caregiver or family member, they're the one, and often they're also going to be the proposed guardian, and they're, the ones in that situation who can talk about whatever other efforts. We took my mother to an attorney to have her do a power of attorney, but, or the doctor could testify that she was at that point didn't have capacity to do a power of attorney. So that wasn't an option. There's a family member that is, posing a risk, and you just want to establish that there is not another alternative, and that guardianship is the solution to the issue that's, that the caregiver or the family member is seeing. If the petition's granted, so the court, that's what in your filing, you propose a decree. The court favors obviously a limited guardianship, and to whatever degree, the guardianship is only going to be established for the purposes that are necessary. I mean, in the real world, it can sometimes be very challenging to craft a limited order, and especially with knowledge that in many cases, the person's capacities are going to continue to decline. And so having the guardian have to keep coming back to maybe expand their duties, it's more challenging, at least in my experience in real life, but you do your best. And if it's clear, for example, nursing homes often petition because they have somebody who has no family and they need to get Medicaid for that person. And if you're ever on the other side, you take a court-appointed case, you'll see that. Well, you can ask, well, okay, even if that's necessary because you need to do that, why is it a plenary guardianship? Why is it ongoing? Once you get the information you need, the person's on Medicaid, they don't really have any money, and they're in a nursing home, so I wouldn't think that their health care and their personal safety better not be at risk. So maybe we just only have the guardianship for the purposes of getting Medicaid benefits in place, and then it should end. Something that's a little more concrete like that. The third part of our, when to file, how to file, and what comes after, or as Heather put it, now what? The statute, I won't, quote word for word. You can read in the statute the full list of powers and duties of a guardian. The guardian of the person, is primarily, is what it says, is that, the person's health care, their day-to-day care needs, health and safety, possibly needing other kinds of services, residential services, or making sure they're getting in-home care or whatever to address the activities of daily living, and other kinds of things like, and often, it's possible that a person can live by themselves. There's a whole, as we all know, there's a person's disability runs the spectrum, and they could have limitations in one area but not another. And so, the guardian only hopefully needs to have province over those things that that person can't do for themselves, and without which they're going to be at risk. It's also important to know there are limitations on the power of a guardian, and they're laid out in the statute. Those first three bullet points are, as I said, those are powers controlled by another statute. So, people say, well, so-and-so's, having a behavioral health or psychiatric episode, and well, I want a guardian so I can, have him admitted. Well, there's another statute. There's the Mental Health Act. that establishes the criteria for someone's admittance to an inpatient facility on an emergency basis or against their wishes. So a guardian, it doesn't have plenary authority, or it doesn't get to skirt that due process if they feel that their ward is in need of psychiatric services. They still have to follow the 302 process. Similarly with family law and domestic relations relinquishment of parental rights. And there are certain things that listed there that just that the initial decree is not going to encompass, that you're not going to throw the kitchen sink in there, and that if there's a need that arises and the guardian can come back and show the court that they need that power, or that it's necessary to grant them the authority to do any of these additional things, but they have to make that case. And one of the biggest ones that comes up is end of life decision making. And so even though if you look at the sample decree, unless that's part of the reason that the guardian's being appointed because there's an end of life, and the person has to have, and there's case law, it's called DLH, it's the INRI DLH, that you first have to establish that the person is actually in an end stage condition, which is defined by law, before a guardian could have to prove to the court that it's in the best interest of the individual to terminate treatment or end any extraordinary measures. So, again, as it should be, it's a high bar. And then the other big, what comes after, are guardianship reports. So as of, I think 2018 or 19, I can't remember now, I think it was 2018. All the reporting was moved to this guardianship tracking system called GTS. They're all done online. There are samples, as I said, in the handouts of the guardian of the first report, actually, let me back up. The first report that's due is 90 days after the decree, is an inventory, which is just basically an assessment and a report on all the assets of the incapacitated person. And that's just a one-time report, and there also needs to be a final report if the person, when they pass away, is still under the auspices of a guardianship. Then there are annual reports, and those are the ones, this all goes through GTS, but the annual reports are the ones that, can be somewhat onerous and have to be done through the GTS. I think they've worked out a lot of bugs, but you find, if you have clients who are possibly an older adult themselves, and maybe their guardianship is over a disabled child or grandchild, and whether or not they're facile on the computer or even have access to the internet, it becomes problematic. I think they're trying in the counties. They have volunteer attorneys that will help people, and the GTS folks, they have technical assistance, but it still can be a big problem. I've gotten involved through APS, and some of you may be aware of this if there's people from court on, but that, like, the people, if the reports aren't done, it's referred from GTS to the county, to the orphans court in the county. In Philadelphia, they've done these sort of call of the list where they bring everybody in to say what's going on. Sometimes it's a good thing because they have started to line up some volunteer attorneys or even paralegals. It's not, it's not rocket science, but and then they can, someone comes to court and they just say, I didn't know how to do the reports, or I didn't know I needed to do the reports. And the judges may connect them with attorneys that the Bar Association has provided, and things like that. But other people don't show up, and then their decrees are issued removing them as guardian, and it's just a big mess. So that's why, I mean, the reports have to be done, but if you can avoid, if there's no need for guardianship in one of those areas, it's just one less burden on the folks, some of whom, you know, it can be a real problem to get the reports done and in on a timely manner. Sustain the reports, inventory, annual reports, final report. And that's sort of the presentation. I'm got, you know, it's good because we leave a lot of time for questions. But I think, again, you know, if to sum it up, I mean, you try to work out, and hopefully that, you know, part of this that was just the nuts and bolts, and you can look at the handouts to kind of, you know, if you're filing a petition, just to see, you know, how it works. But, you know, a lot of the work of this comes in the front end, in my view, of really establishing the need for guardianship and that it's the right solution to the problem, and talking through with your client whether there are alternatives that'll address whatever's before them. If it's an area that's of interest to you, I would also suggest one way to get experience is to volunteer in Montgomery County or Philly or wherever. Get on the list of court-appointed attorneys, so you learn it sort of from the other side, and you can see what the petitioners are doing. You know, the elder law bar is very collegial. If you need, you know, you could call me with a question or whatever. There's lots of attorneys who do this, have even far more experience than I do. But I found I sort of got thrown into it with the protective services cases, but and then you really get a good perspective, I think, to be a court-appointed counsel and see it from the other side and really see how it plays out in court. But anyway, I'll stop, and we've got a good bit of time for questions. Hopefully that's okay, and I'll turn it over to Heather.